Welcome, and thank you for joining Seyfarth's webinar, Trending Legal Topics for the Staffing Industry in 2023. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the webinar over to Rebecca Woods. Rebecca, you may begin.
Thank you, Kristen. Good afternoon, everyone, and welcome to the first of several webinars we'll provide this year that will pertain to the staffing industry. Many of you probably already know this, but Seyfarth has long had a high-quality, interdisciplinary, and full-service approach on staffing company issues. And so we're delighted to talk with you today about the trending topics for 2023. Let me briefly introduce our co-panelists. First, we have Ben Briggs. He is the co-chair of the firm's Workplace Safety and Environmental Practice Group. He's located in Atlanta with me. He counsels staffing clients in a wide variety of employment topics, including contesting, litigating, and negotiating favorable resolutions of both federal and state OSHA citations, as well as representing employers in federal and state OSHA inspections. Next, we'll have Scott Hecker. He is the senior counsel in our Washington, D.C. office, and he came to us from the Department of Labor in the Occupational Safety and Health Division. He advises clients and litigates on their behalf under numerous federal labor laws, including the Occupational Safety and Health Act, Mine Safety and Health Act, Black Lung Benefits Act, FLSA, and Service Contract Act. We also have Andy Scroggins. He's a partner in our Chicago office. He specializes in complex class and collective action proceedings, with a significant portion of his practice focusing on matters concerning the EEOC. He handles administrative charges, systemic investigations, subpoena enforcement proceedings, and pattern and practice litigation. We also have Annette Timon. She is the chair of the Seyfarth's People Analytics Group, which gets the award for the coolest name that we have. She leads multidisciplinary teams of attorneys and a bunch of non-lawyers, which is pretty cool, labor economists, data analysts, and other professionals. And they develop data-driven solutions to solve complex workforce issues. Annette provides counseling and litigation advice on workforce strategies using data analytics, with an emphasis on pay equity, diversity, inclusion, and people analytics. And finally, last but not least, you have me, Rebecca Woods. I'm a partner in our Atlanta office, and I'm mama bear to the group of litigators here as the head of the Atlanta Litigation Group. Also, my affinity for complex contract disputes got me a role as the co-chair of our National Commercial Litigation Practice Group. So, with all of those intros, let's jump into the substance. I go first, and as your resident contracts disputes guru, or at least for this webinar, I'm here to talk with you about indemnity provisions. Now, these are evergreen, they're ancient, but particularly in an uncertain economy where, as you'll hear from our co-panelists, trouble is brewing and someone has to pay for it, we need to talk about indemnity provisions. So they are the unsung heroes of the contract. They're unsung because they don't get a lot of attention unless you really need them. And they provide for risk shifting, and basically they're free insurance. If your client is getting sued, or you want to sue somebody and you need help paying for it, sometimes the indemnity provision can step in and you didn't have to pay a premium for it. But these are often boilerplate, they often aren't negotiated, and many people, including lawyers, don't understand a lot of the nuances of indemnity. They're not that easy. In part, that's because they're governed on a state-by-state basis, and they're principally governed by common law. That means judges are issuing decisions about what indemnity law means in that jurisdiction. Sometimes there's statutory law that governs this, but then you have judges going off and interpreting the statutory law. So maddeningly, there are 50 plus indemnity provision laws in this country, basically. And because state law varies, it's important to know that various terms that we all think we know what they mean may not actually mean what you thought it meant in that jurisdiction. For example, there are states where you don't have to say, I will defend you in order to incur an obligation or a right to a defense. There are some states that simply say hold harmless will cover essentially what indemnify and defend mean. It depends on the state. Also importantly to know is a lot of people think, at least sometimes we can harken back to law school, that you can't be indemnified for your own negligence. Now, in the construction contract space, a space I occupy fairly heartily as well, you actually can't do that. There are anti-indemnity provisions that say you can't shift over to somebody else the cost of your own negligence. But in the staffing company world and in other commercial contracts, you can. But it depends, and you have to do it in certain special ways in certain jurisdictions. And finally, I think this is one of those most maddening new things that people, when they discover indemnity provisions and they start learning about them, they start to learn that there is a handful of states where a defense in a commercial civil contract will be treated by a court in the same way that defense for insurance is treated. And that's important because in the insurance realm, if you are sued and an insurer is supposed to respond and provide you a defense, which is a lot of money and sometimes absolutely far exceeds the cost of the actual liability and exposure in the case, that insurer has to defend you soup to nuts, even if the claims are baseless, if they're stupid, or if they only partially are covered. And so many people would argue, myself included, that it shouldn't be the case that in a commercial contract where you don't bake in the value and the cost and the risk of having to pay for somebody else's defense and litigation, that we should apply this, what we do apply in the insurance context, where, by the way, you pay a premium for that right. But nevertheless, it's a big potential exposure, and it's something that folks need to know about. So turning the page and looking at, and particularly going forward in 2023, when in this period of uncertainty, we're looking forward to more certainty. Here's what you should look for out of yourselves, out of your business folks, no matter which side you are, indemnitor or indemnity, and also look for from your attorneys. Number one, and these are just some headlines. There's a lot more nuance to go to. But number one, you're going to want to think about which jurisdiction's law applies to the contract that you're negotiating. Now, that sounds cute, I'm sure many of you think, because many of you are practicing or have business in multiple jurisdictions. And that's a little bit of a pickle. So you're going to need to have somebody thoughtful think about what are the exposures, what kind of protections do we want, and how can we articulate the language that we want that captures the most, that is the lowest common denominator. The next thing to think about are the actual mechanics. I'm always surprised at how many indemnity provisions I see that are just a single paragraph and basically outline indemnity rights or obligations, and that's it, and don't talk about the tender of notice and the timing of notice, and when does the duty defend kick in, and what is the scope of that duty of defense, who gets to control the defense, who gets to control which lawyers are selected. Those are important elements that sometimes you'll come across an indemnity provision that really lays those pieces out, and they can protect you again, whether you're indemnitor or indemnity. The next thing you'll want to watch out for is address the inclusions and exclusions carefully. Nexus phrases are important. They exist in almost all of these indemnity provisions that I've seen, and those are things like caused by or related to or resulting from. And those are important because they either broaden or they narrow the scope of the indemnity. And so some thought should be put into what is the scope of indemnity I'm negotiating on behalf of myself or that I'm agreeing to provide to the other side. You're also going to want to think about what kinds of things am I actually providing indemnity for? Is it somebody else's negligence? Is it a breach of reps and warranties? Or is the bar higher? Is it intentional misconduct or gross negligence? Another thing you're going to want to think about is the degree to which limitations are outlined in the indemnity. Contract people like to use fun little terms. Liability basket is one of them. That's basically a self-insured retention. Does the indemnity provision that you're looking at require that the indemnity first hit a certain amount of money before it moves over to the indemnitor? And that can save a lot of headaches. Is there a cap? Should there be a cap on the scope of indemnity? Should there be materiality qualifiers? Additionally, and this is a little complex, but a lot of people miss out on the interrelationship between the indemnity provision and the insurance provisions. In almost all contracts where there's an indemnity provision, there are also mandatory insurance provisions. And some of my clients have come to me and said, but I thought my insurance would cover it. But insurance sometimes doesn't cover what your obligation is when you have agreed to indemnify somebody. So you're going to want to make sure you understand how those pieces of the puzzle fit together. And then the final headline for 2023 would be consider the survival period or the claim deadline. Many people don't realize that although there are external statute of limitations, you can impose a statute of limitations within your own contract. And often what will happen is a client will get sued and they'll be defending, and then somebody along the way will say, wait, you have an indemnity provision. We should go to somebody else, or maybe there's already a liability determined. And then that time period closed by the time you should have made the claim. And as an indemnitor, on the other hand, you're going to want to probably limit the time of your exposure. So there is your 10 minutes on Indemnity 101 for 2023. And let's hand it over to Andy Scroggins, who's going to tell you about the changes at the EEOC. Andy?
Great, thank you, Rebecca. Let's go to the next slide. So there's a lot going on at the EEOC that has impact for those who are in the staffing industry or who use the services that they provide. Every 5 years, the EEOC publishes what they call their Strategic Enforcement Plan, or the SEP. And what they do in that document is outline what their enforcement priorities will be over the next half decade. And what we saw in the prior version, the one that just expired, is that the EEOC called out specifically that it intended to focus on staffing agencies as a subject for greater enforcement. They just in January published a proposed new SEP. It's in the Federal Register for comment and will go into effect likely later this month. And while they've changed what they say about staffing agencies, it's still a new focus with some nuanced changes that we'll talk about here. And why does that matter? Well, we saw that under the prior SEP, the EEOC really did follow through on what it said it would do. It increased its enforcement efforts against staffing companies, including taking staffing companies into litigation. And we're seeing that there are a lot of changes happening at the EEOC right now that we think are going to lead to across the board increases in enforcement activity. So those of you who are in this industry or use the services of those in this industry should be on the lookout for that. Let's go to the next slide. So when the EEOC published its prior SEP, it identified staffing relationships in what it calls the emerging and developing issues category. So it meant it's a new area of focus that the EEOC wanted to look at. And they were particularly interested in trying to understand what's going on with more complicated employment and workplace relationships. So companies that are using a mix of their own direct employees, independent contractors, people placed on assignment by staffing agencies, and understanding how that mix overall might impact equal employment opportunity issues. With the new proposal that was just published, they've moved that area of focus out of the emerging and developing issue category. What that means is they no longer consider this to be kind of new, fresh ground. But what they have done is to continue to identify staffing issues in some other contexts. So one of the ways they've done that is to put a new focus on what they're calling vulnerable and underserved workers. And they've defined it in some interesting ways. You wouldn't necessarily think of that category as applying to staffing, but they have included temporary workers under that category. These are folks that they think may not understand their rights as well as others do, or may have some reason to feel like they can't exercise those rights to the same extent as others. And so it remains a focus in that sense. And let's go to the next slide, and we can talk about some of the ways in particular that the EEOC might be focusing in on staffing relationships. So they've continued forward an earlier priority, which is to eliminate barriers in recruitment and hiring. But some of the specifics that they've added in this new SEP, or the proposed SEP, really do get to the heart of staffing and the way that companies use staffing. So we've listed here some from the document that we think are applicable. But you'll notice that the EEOC is focused on examples where, you know, are people in protected categories being funneled into temporary work rather than given the opportunity to apply for permanent positions? Are temporary work assignments being used in a way that denies people advancement opportunities? Are we seeing steering or segregation based on job so that, a protected category becomes very dominant in a particular role within an organization? Now, all of these are going to be challenges, right? Because one of the things that you'll hear is, some of the challenges between how much control the company using staffing services exercises over the people who are placed on assignment, how much of that needs to be handled by the staffing company. And this suggests that, at least in some ways, the EEOC is anticipating that there will be a level of cooperation or analysis against these different work populations to check whether there are becoming maybe concentrations of people in one protected group into certain types of work. So it's going to be a tricky balance, I think, to figure out, what role each should have and how hard will the EEOC press on trying to get a full picture of the workforce complement at any given employer. Another kind of category that they're looking at, and you'll hear more about this, I think, from Annette later, is using some automated tools to support recruiting and management efforts. And so, for example, they're going to have their eye out on systems that will target advertisements in a way that they think is improper. We saw a series of charges a couple of years ago where people were using Facebook to place job ads, but because the recruiters weren't necessarily the most familiar with Facebook, they're asking the marketing team to post those jobs. The marketing team is focused on getting the most bang for their buck, and so they were trying to dial the messages in to reach very precise audiences, and in some cases the EEOC said that dialing process was excluding certain populations and focusing on others to the detriment of some candidates. So that's an example of how AI can be used potentially for a good reason and then kind of not used properly and causing some problems when scrutinized by the EEOC. And then, any other kind of automated process that the employer might use, whether it's their applicant tracking system or pre-screening tests, all those things are kind of on the radar of the EEOC for additional scrutiny. Let's go to the next slide. So, again, we've seen that the EEOC has not been shy about pursuing litigation against staffing companies or cases that implicate those kinds of arrangements. Just in the last year, we saw 10 lawsuits filed that had some relation. Either they were filed against staffing companies or against people who had used staffing companies to further an end that the EEOC said was potentially discriminatory. They kind of fall into some broad categories. Some of the complaints have examples of people using language that the EEOC says indicates a desire for certain kinds of workers. I see this over and over, but people may be too familiar or casual in their description of what they're looking for. Hey, can you send a couple guys over? Well, the EEOC says that sounds like you're making a request based on sex. Some of the other examples they have in these complaints aren't so innocently explained. There are other euphemisms like heavy and light, meaning male or female roles. There are examples where companies were, for example, there's a laundromat company and they would have only men in jobs that required lifting and that kind of work, and only women doing things like ironing. So, obviously those are going to be problems, and you want to look out for how you're communicating with your staffing agency, and if you're the agency, making sure you don't honor requests that are potentially discriminatory. Another area where complaints come up frequently is in accommodation. There were 2 complaints filed this year about somebody who's hard of hearing and the staffing agency making some unilateral decisions about what that person was capable of doing on the job or not. So that's another tricky area. Sometimes these complaints are filed against just the staffing agency. Sometimes they name both the agency and the client as defendants. And then there are some other examples where even though the client of the staffing agency is not accused of doing anything wrong, the EEOC names them anyway. So it's certainly a fraught area. And you can see just from the recent settlements that these can be significant liabilities if things get to the litigation stage. Let's go to the next slide, please. So I mentioned at the outset that we're expecting to see more litigation. There are a few reasons for that. One is that the Biden administration has really been pushing this idea of, trying to address systemic discrimination issues, provide equal employment opportunities to folks. The EEOC has received a larger budget. But I think one thing that people don't always recognize is that change in control of the EEOC doesn't track with the change in administration. It actually lags quite a bit. So even though the Biden administration is now a couple of years in, the EEOC has been under the control of commissioners appointed by Republicans. And right now, we had commissioners step down in December, so we have a 2-2 vote right now. There is a Democratic nominee who we expect to be confirmed given the composition of the Senate, and that's going to flip the control to Democrats. So you might wonder, well, why does that matter? Well, that's because litigation needs to be approved by a majority of the commissioners. And until recently, there were enough Republican appointees to veto those litigation requests. So that's going to change. By our count, Republican appointees voted down 16 requests for litigation over the last year and a half or so. So we also think, and there's some information to support this, that upon seeing that the commissioners weren't approving all of the litigation, that maybe some of the regional attorneys and the general counsel were holding back on bringing up their new cases. So we think there's a backlog waiting, and we think that once there's a new majority of commissioners who are Democratic appointees, that we're going to see these being presented more and see more litigation activity going into the future. So before I turn it over, I'll add one last plug. We did just drop our 2023 EEOC initiated litigation report that's on the website or available if you want to email me. It's got more detail on all of these topics. But with that, I will pass it to Annette.
Actually, Andy, we do have a question that I think we could address now. We have someone who's asked, could we take a moment to define what we typically mean when we say, quote, staffing agency versus a, quote, temporary agency, for example? Are they being treated as equivalent when we say staffing in this presentation?
Yeah, so they are being treated as equal for these purposes. For the EEOC, they're really looking at any variation on a workplace relationship. And we did see litigation against, both agencies that place people on temporary assignment and also those who are kind of doing the recruiting legwork for companies and sending people over to be hired directly. So here I'm using it in a more general sense because I think that's the way the EEOC approaches it.
Thank you. Annette, would you like to begin?
Okay, yeah, absolutely. So we're going to now turn to talking a bit about the trend towards pay transparency. If we go to the next slide, you will see that there really has been a significant push in the last several years with regard to pay equity issues and calls from various stakeholders for agencies, states, federal legislation to really push the envelope and address issues with regard to the perceived wage gap. So two things that I'm going to touch on today are the wage disclosure requirements that have popped up significantly. We now have 15 jurisdictions, and we are closely monitoring pending legislation that is coming up on the issue of wage range disclosures. And then also we'll talk about pay reporting requirements. The most significant, I think, especially for this audience, is the California pay reporting requirements that are coming up. If we go to the next slide, we can dive in on pay data reporting. Now, in response to the question that came up, I'm going to introduce a new term because the California legislator came up with a new term called labor contractor. And a labor contractor in this setting that we'll be talking about is any individual or entity that supplies either with or without a contract a client employer with workers to perform labor within that client employer's usual course of business. So that's a very broad term, but it has some significant implications for this group. We just actually did a webinar yesterday on this pay reporting requirement alone. For many employers, the requirements have been in place since 2020, at least for private employers to report on their own W-2 employees. However, there was legislation that was introduced late last year, or early last year, and then signed into law in September, that is now going to significantly expand the reporting requirements, and those new reports are going to be due May 10th of 2023. So there's not a lot of time here. What it essentially means is, in addition to private employers who report on their own, the compensation of their own workers, there will also be a second required report through what California is defining as a labor contractor. And the private employers not only have to complete their own report, but also need to produce data with regard to those labor contractor employees that perform services for them during a defined time period in the previous year. This is a very hot trending issue right now. The FAQs were just released on January 20th. We've seen some additional information coming out just in the last, even over the weekend, and just yesterday. The template materials that are driving this were just posted. So if you're not aware of that, please keep an eye on that, and certainly refer to the California Civil Rights Department's webpage. If we go to the next slide, I'll talk about the key changes. So as I mentioned, we've got a new timing. So May 10th of 2023, the report is going to be due. This does apply even if an employer does not already have an EEO1 filing requirement, and that change has been causing a shift for staffing agencies in particular that perhaps did not previously have an obligation to report on those workers that went out to support client-employer work. So that's a new development. And in addition, there's going to be some new data requirements. So just new pay data in terms of mean and median reporting. But that second report is really what is causing a lot of question and back and forth information right now. So the next slide will describe the two reports a bit more. The payroll report is just going to be, if we go to the next slide, the payroll report will cover those W-2 workers that are employed during the selected period. So again, that one's not new. That second run is. It's going to cover the W-2 labor contractor workers that performed work for the client employer during the client employer's usual course of business. I've got a lot of terms there that are quoted. Unfortunately, a critical one, usual course of business, is not defined. There's really no guidance in California, so client employers and their third-party labor contractor partners are having to navigate what that potentially would mean. What I will say about this particular piece of legislation is that it really will require a lot of collaboration between the staffing agencies, temp agencies, define it as you will. It is those labor contractors and their client employers, because the legislation does require the labor contractors to provide the necessary data for employers to compile and submit that data to CRD, and it's a lot of information. So it is W-2 wage hour information. Labor contractors have to separate out and provide that data to each client employer very specifically with regard to the pay that an individual received for that prior year. So it's quite burdensome, and there's actually not a lot of time given the time frame that we have received. The next slide, I'm not going to go into a lot of terrible detail here, but I thought it would be helpful to have the data here for you all, because I know you're going to be getting the reports. Like I said, we did a whole full-hour presentation just on this particular topic alone, but you see the two different kinds of reports and who would need to be included. If we go to the next slide, I'll talk about Illinois a bit as well. This is also a new pay reporting obligation that employers in Illinois have. It just started last year. Technically, the law is that by March 24th of 2024, all Illinois employers are going to have to provide employee level detail regarding their Illinois workers and the compensation that they had. However, because if you can imagine, that's a lot of data that the agency is going to be obtaining, the Department of Labor implemented a staggered approach. So the first step is that employers in Illinois were required to register and provide their contact information to the Illinois Department of Labor, just to say, hey, here's who I am and here's how you find me, essentially. And then what happened is that the IDOL set up staggered deadlines, and they give each employer a specific deadline by which to provide their information. This is pretty detailed information. It is the only state that requires the production of employee level compensation data. They are doing some data review and analysis. So if you're not aware of this law, it's really important to take a look at that, because unfortunately what's happening is the state went out and just purchased employee lists on their own, and they have sent out notices with regard to deadlines to Google emails and Yahoo emails, and then the employer is, later being caught up through a different mechanism that they use to say that they have missed their deadline. So if you're not aware of that, make sure you're tapping into it. The next couple of slides will just identify the types of information that is required. So the next slide shows the equal pay compliance statement. And it does require employers to certify that they are in compliance with all of these, requirements. There is no wage disparity. They don't have sex-based personnel decisions. They require employers to share how often they engage in wage determinations and when they conduct the analysis of compensation. So it's a lot of information to be shared. And then the last slide talks about the employee wage level detail that employers will receive. So that's the wage data slide on the next page. So you'll see name, last four digits of a social, gender, race, total wages. So it's a lot of information to make sure that you are providing to the agency. The next slide, I'm just going to move quickly to the pay range disclosure requirements. Here too, this is what I will say about the pay range disclosure. There are three sort of approaches that we're seeing. Some states have adopted a requirement that employers affirmatively place on their job posting what the pay scale is with regard to that particular position. The second bucket of states or jurisdictions that are addressing this are saying, okay, at some point during the application process, you're going to have to provide it. It's often at the time of the first interview or at the time, an initial offer is extended to a candidate. So there's the affirmative requirement that the employer has to provide the range of compensation for that particular job. So then the third option is, it's more, upon request. And so those obviously are easier to manage, except that many employers do not have well-defined pay ranges. And each state and jurisdiction is taking a different approach. Some are saying, what is reasonably expected for the position. Others are saying, well, that is the law, but they're interpreting that to mean it's got to be from the top of the scale to the bottom of the scale, including anybody that's paid outside of it. That somehow is the reasonable rate that someone might receive. That's the law in Washington. I've highlighted New York in particular because they do, all the New York jurisdictions, and New York State will go into effect later this year, but all of the New York jurisdictions do exempt the staffing agency industry from this particular requirement. The others do not affirmatively state that there's an exemption. So it is a point to consider. And then the next few slides really bucket out each jurisdiction. So I won't spend time going through that except to have them on here so that when you get these decks, you'll have that information in the buckets that we're describing. So you can take a look at the specific jurisdiction, what the timing is in terms of when the data needs to be disclosed, and then specifically what needs to be provided on that disclosure, because especially if you're a national employer trying to navigate the various requirements, It is very complex, especially when you think about, workers that are not necessarily tied to a specific location. So with that, I'm going to turn to the next section, which is artificial intelligence. When I use that term, it's probably broader. We're seeing this terminology now referred to as automated employment decisions. And I will just say this, there is a significant increase in focus by agencies and jurisdictions across the states concerning artificial intelligence issues and automated employment decisions. As Andy mentioned, one of the priorities that the EEOC has described in their current SEP is a continued focus on technologies that are involved in the hiring process. In 2021, EEOC did announce an initiative that specifically focused on AI issues and making sure that these tools are being implemented in a non-discriminatory way. I will say that the general feel from the agencies is that there's a lot of skepticism. While employers in the business community are very excited about the possibilities and the efficiencies that are going to be provided, ensuring that you're more timely processing applicants through your system, finding people, looking for talent that's out there that maybe you would not have been able to assess in the past, I would say that there is just a general skepticism with regard to these tools. And so we're seeing a lot more guidance. Just Tuesday of this week, the EEOC has been engaged in a lot of listening sessions. They provided some guidance. They did have a hearing on Tuesday. The opening speaker talked about her first case that dealt with working with a staffing agency and some of the, kind of parade of horribles, what happened, that occurred in that specific context, and used it to say, if that sort of obvious discriminatory practice is somehow embedded in an AI tool, the concern that there would be for AI tools and the bias that they could introduce in a hiring process. So there is a lot of focus around what is being used, how it's being used, who is using it. Certainly here in the U.S., I would say that the employer is the one who's going to bear the bulk of the responsibility, but they do have to work with their partners in terms of staffing agencies that are filling roles. So we will see this coming up. OFCCP is also focused on this particular issue. If we go to the next slide, we'll just see some of the states that have implemented or at least introduced legislation. I will say New York City is the one that's come the furthest. They actually have a law in place. The regulations are being finalized and reviewed. Right now, there was just a hearing, I believe that was last week or maybe the week before, on an amended set of rules. We testified on those because it really is quite broad in terms of the obligations that there will be on the employer and anyone involved in their recruiting process. The next slide just touches on the significant issues that we're seeing. So for example, coverage and scope. What are the laws, or what are the tools, that are being captured by these laws? We often traditionally think about just at a high level, those super technology tools that are deriving predictions. That's not quite the case in terms of how we're seeing this. They are looking at tools that just just identify and categorize individuals. There's notice requirements about the tools, how they're being used and how they're being accommodated, audit procedures, there's privacy issues, and just general enforcement on these issues. So that, I know, is a lot of information to share, but this is what is on the road ahead on those two issues, both pay transparency and artificial intelligence. And so with that, I'm going to turn it over to Scott and Ben.
Thanks, Annette. Appreciate that. We're going to cover OSHA temporary worker initiatives and enforcement. Scott and I are going to tag team this. I'll talk quickly about OSHA's temporary worker initiative, which has been around for a while, and both staffing companies and their clients are likely familiar with it. And then talk about industry-specific challenges that both staffing companies and their clients confront as they work through what OSHA views as a shared responsibility for workplace safety and health. And then Scott's going to close us out with a discussion of some strategies for both staffing companies and their clients to navigate that and make sure that their on-the-ground practices align with OSHA's temporary worker initiative, which is really the way to try to stay out of compliance trouble. We'll talk about those things against this backdrop. 2023, we expect to see OSHA return to aggressive enforcement. Obviously, there have been pandemic-related distractions, and that the agency spent a lot of its focus over the last few years on that. And as a result, we didn't see a whole lot of policy making or things shifting in the way that you ordinarily would when a new administration comes in. But we're starting to see those things now, and there's a good example of something that they did within the last couple of weeks where they're going to start looking more closely at citing employers for instance-by-instance violations, meaning every single time something happens, it can give rise to a separate citation. And they're focusing, according to their press release, on employers that put profits over safety, which is a refrain that we hear from the agency pretty regularly. So turning to the temporary worker initiative, this has been around since about April of 2013. It's part of a concerted effort by both OSHA and stakeholders to ensure that temporary workers are protected from workplace hazards through enforcement, outreach, training. OSHA worked on this and collaborated to some extent with the ASA on it, and so the staffing industry had a lot of input into what that framework looked like, and it does provide excellent guidance if you haven't seen it for navigating these issues. State agencies like Cal OSHA in particular have instituted similar programs. In California, the touchstone of an agency's responsibility, a staffing agency's responsibility, is to take reasonable steps to evaluate the conditions that temporary workers are going to be exposed to by doing periodic worksite inspections, okay? They need to ensure also that their employees are covered by an IIPP and other safety programs that relate specifically to the assigned work, and ensure that they're properly trained and provided with necessary PPE. There's also an obligation in Cal OSHA's eyes to instruct employees that if they're assigned work that they reasonably believe to be dangerous, that they can refuse to do that work and ask for a different assignment from their staffing firm. Since the temporary worker initiative went into effect, what we've seen is that staffing firms have been subjected to greater scrutiny, and their practices have been subjected to greater scrutiny during inspections that typically take place at their client sites and involve accidents or complaints that occur on those sites. Prior to 2013, it was somewhat unusual for staffing firms to be involved in protracted OSHA inspections. We've seen a big shift in that, where now both the staffing firm and its client are sort of in lockstep during those inspections, and both are heavily involved. We can turn to the next slide, please. So why did OSHA launch the initiative? The part of it is what Andy touched on, which is an observation that there's been an increased use in temporary workers. There's a belief that temporary workers are at an increased risk of work-related injuries and illness, and some do not receive adequate training, and the data sort of bears that out, that temporary workers tend to get hurt on the job more frequently than folks who are employed directly by the host employer. Oftentimes, temporary workers are assigned to more hazardous jobs that host employers don't want to assign to their own internal employees. And then there's this dynamic where a temporary worker, because of the sort of itinerant nature of staffing, tends to be new to a job more frequently over the course of a given time period than somebody who's working directly for the host employer, and that creates the potential for a lack of understanding regarding how to conduct a job safely on a more frequent basis. OSHA believes that some employers use temporary workers to avoid compliance obligations and or do not want to invest in training for temporary workers. Now, of course, that was part of the rationale at the beginning. We've seen a pretty significant shift over the last 9 years, 10 years now, since the temporary worker initiative has come into effect, and see a lot more collaboration between staffing firms and their clients on safety issues. And then that sort of ties in with what OSHA perceives as the communication gap. And again, we're seeing a much more robust approach to temporary worker safety because of the collaboration between staffing firms and the businesses that they work with. OSHA's position is clear on this, that shared control of temporary workers equals shared responsibility. It's very difficult in this context to shift the entire responsibility to either the staffing firm or to the staffing firm's client. So there are roles to be played by both, depending on who's sort of in the best position to address a particular situation or a particular type of training or PPE. Let's go to the next slide, please. This is sort of a chart that shows industry-specific challenges, and while it's put together through the lens of a staffing company point of view, it's really important for both staffing firms and their clients to consider these observations about challenges that are unique to this kind of employment relationship. Because if you're not thinking about these things, then what occurs almost inevitably is a compliance gap. And those compliance gaps, if they affect the staffing firm or they affect the staffing firm's client, they're typically going to have implications for the other partner to the relationship. So what do we mean about insufficient communication about roles? A lot of times there's a right-hand, left-hand problem as between the staffing firm and its client. They don't know who's going to manage a particular aspect of the overall workplace safety, and as a result, it gets overlooked. And then when something occurs, you've got them pointing fingers at each other about who was responsible for it. So that's something that is important to do up front when a relationship is initiated, and that it's revisited periodically because circumstances or jobs or conditions can change. Changes in job duties. Sometimes we call this scope creep. We see a lot of situations where temporary workers are sent out to do something like a general labor position, and then over time they might evolve into doing something else that's more hazardous, like operating a powered industrial truck, and oftentimes that can give rise to compliance gaps with regard to training and safe operation, because it's not communicated between the staffing company and their client, and so there's not an opportunity to revisit what needs to be done to make sure that person is properly trained. Verifying site-specific training. The staffing firm and its client need to be on the same page regarding site-specific training. Typically, the host employer is going to be in a better position because it's got more knowledge about its operations and the hazards associated with it. Not always the case, but typically that's true. And if there's a push to shift it away from the host employer to the staffing company, a lot of times the staffing company doesn't have the expertise to do it right. And again, what that opens you up to is a compliance gap that can lead to enforcement against both entities. And then there's this issue of a lack of expertise and lack of knowledge about the site. The guidance, OSHA's guidance, says staffing firms don't have to be experts in their client operations, but that also doesn't mean that staffing firms can stick their heads in the sand. And so some level of understanding by those who check out client sites and have responsibility for doing that and kicking the tires on programs is important. And what we see now is that a lot of staffing firms have invested in internal training programs for people like account managers who go out and visit client sites so that they know how to spot issues and collaborate with the clients and in a lot of instances add value to the relationship. Exclusion we don't see exclusion of temporary workers from site-specific training in a lot of instances anymore, but it can happen, and sometimes it's driven by a belief that including temporary workers in certain aspects of what direct employees of the host employer go through can increase the chances of joint employer liability and in other circumstances like wage hour or unionizing efforts and those kinds of things. And so we sometimes see a real effort to divide the two employee populations from one another. Temporary worker feedback. Every staffing firm that I've worked with in recent years has a requirement that their temporary workers notify the staffing company if their job changes in a way that doesn't align with the training they've received, or if they think that the job is unsafe for some reason. And that, unfortunately, that sort of policy and training tends to go in one ear and out the other. And so Scott will have some suggestions for you about how to overcome that gap or disconnect that we sometimes see, because it's very unusual for temporary workers to come back to the staffing agency and say, hey, this has changed, or I've been asked to operate a forklift and I'm not trained for it. A lot of times, what you'll hear is that the employees, the temporary workers, are simply afraid to rock the boat, and there's probably some truth to that. I'm going to turn it over to Scott now, who's going to talk about strategies for overcoming these obstacles, and wrap up with him. Thank you.
Thanks, Ben. We can go to the next slide. So yeah, we're just going to talk about some recommended practices. Obviously, there's the key is communication, right? Ben has talked about sort of some of that compliance gap, and that kind of comes when the agency and its host, its client, are not, keeping in good communication and making sure that the temporary associates who may be placed with the client are sort of in that same population, receiving the necessary training, site-specific training, and those kinds of things. So it's important to contractually define the responsibilities and make sure it's reflecting what's the actual on-the-ground practice and execution at the host site. Staffing agencies should, as part of that, review the work site safety programs for the host, any logs that are required to be kept, OSHA 300s and those kinds of analogous logs for state agencies before they assign workers to the site. So you have an upfront expectation and understanding on both ends of the relationship of what the workers may face. Has been noted, it can be that temporary employees are new or less familiar, so they get assigned, or they're new to the job or less familiar with the work because they haven't been there that long, so they wind up suffering more injuries or sometimes get assigned to more hazardous jobs. So if there's an upfront expectation and knowledge about what will go on and what what kinds of hazards there may be on both sides, the entities can work together to ensure that the temporary workers are protected along with the rest of the employee population. Maintaining that communication could include conducting periodic assessments, as Ben referred to earlier. You'll want to identify those change conditions. That's one way to do it without relying on a temporary worker, quote unquote, rocking the boat, right? If you have ongoing communication and a good relationship between staffing agency and client, then those communications can come at the more corporate level rather than relying on your employees to make those decisions and identify where the hazardous conditions may be shifting or changing. Again, knowing what the workers are going to do, what those hazards might be that they'll be exposed to through those responsibilities, and how the host will address those. And again, goes back to defining what role the host plays versus the staffing company in dealing with hazards. What can each company anticipate and prevent? That should be sort of a catchphrase for how you deal with this kind of issue. Ben mentioned staffing agencies aren't required to be experts on their clients' operations, but that doesn't mean you pull an ostrich, right? You do need to have some understanding, and these periodic inspections, it's not a question of going and saying, well, I work in an office, you guys are doing welding, but I don't think you're doing it right. You need this extra PPE. That's not what we're saying. What we're saying is if you see something that's an obvious hazard or potentially could be addressed in a different way, it comes back to that communication and really reminding or engaging in that relationship to make sure you're doing the best you can reasonably to protect the workforce. And again, where there may be these more hazardous duties, make sure there are limitations around them. Make sure there's an understanding of what they'll be and what the exposure could be for the temporary associates. If we go to the next slide, we see that training is also going to be key, right? We talked about newer, less experienced temporary associates who may be placed with a host. They may not have a background in some of the site-specific operations. And so there does need to be that training, and it should be coordinated up front. Who's responsible for what? It could be that the staffing agency, and it often is the staffing agency, providing sort of a basic generic safety and health training with overviews of the concepts underlying PPE, hazards, HAZCOM, hazardous communication, those kinds of things. Again, they should be trained that they should report back, probably both to their host employer and their host site and their actual employer, the staffing agency, on things they're seeing that may be beyond their duties or changes in jobs, and then do something to make sure that training's happening. If you're on the staffing agency side, the site-specific training that host employers will provide, so that those temporary associates are provided with the same or equivalent training as the employer's full-time workers. That's because they're going to be operating shoulder to shoulder, so there really shouldn't be a distinction in the type of training they require and they need to operate in the particular workplace. And again, because the host is better situated to address site-specific issues, that's why the allocation of responsibility for training and identification of those kinds of issues falls to the host, whereas the kind of upfront orientation, general safety and health training would more appropriately fall to the staffing agency. And if we could go to the next slide.
Yes, just before we go there, I'd like to read out the CLE code for everyone. The CLE code is SS, as in Seyfarth Shaw, SS 8874. Once again, SS 8874.
And just to continue some of these recommended practices, we mentioned earlier the option to do periodic assessments or periodic inspections, just reassessing how things are going and continuing to actively engage in the relationship between staffing agency and host employer. Just makes sense. You should discuss the safety issues. If there are open issues or if there was, unfortunately an incident, make sure you're closing the loop on that, not leaving it open-ended. And you're documenting the actions that you took to address and prevent, future circumstances from leading to future incidents. That's going to be helpful in demonstrating to OSHA that you're taking this collaborative approach and you are working to reduce the hazards, mitigate risks, and address any issues that you become aware of on both sides, again, of this relationship. That's where the communication is key. The staffing agency, again, you're going to see them exercising that reasonable diligence at the front end to ensure that safety is a consideration before placement, and to demonstrate how the host is maintaining its safe environment. Both, again, should remind their employees and the temporary associates placed with them to identify these hazards, to identify changes in conditions or duties. But as we said, engaging in that ongoing reassessment and periodic inspection will help take some of that burden off of the employee who, to Ben's point, may be nervous about raising these kinds of issues. Certainly, the host employers should let staffing agencies know, and this should also probably be something contractually memorialized when there will be a change in duties, so that the staffing agency can evaluate whether that employee has the skills to sort of shift duties and ensure that the proper training is given at both ends for that employee to make sure they're operating safely once they land in that new role. Progressive discipline policies make sense too. If you need to enforce rules because there have been safety issues, if there have been violations on the part of temporary associates placed with hosts, there should be an effort to coordinate what's the appropriate response and discipline to those. And I think with that, as we come upon 12:59 and 42 seconds or whatever we're at here, that's the last of our content. We did note that we will be providing the deck and a recording, and we can do our best to reach out to folks who had questions that we didn't have the opportunity to answer. But we really appreciate your attendance today, and thank you to my colleagues for all the information, substantive information that we got today. I appreciate it.
Thank you all very much. Have a good day.